We got a lot to cover today, so we'll go ahead and get started here, David. So thank you so much for joining us. I'm going to get through a little bit of housekeeping here to start with, just so everybody knows we are recording this, and we'll be sharing the recording later, so you guys can go back and refer to anything that's in here. Thank you again for joining us. If you have any questions that come up, throw those up in the chat box. Jason, Chubbuck, and Jillian will help us out. And guys, feel free to interrupt us if anything is pertinent to the current slide that we're on. And we will try to get through as many questions as possible. If we can't get to your question, we will answer those. We'll collect those and answer those and email everybody at the end. Just a reminder, this is educational. Everything changes pretty frequently with this stuff, so make sure that you review things. And if you have any specific questions that come up that are specific to your company, feel free to send us a note. We're happy to talk to you about that and see if we can help you guys out. So here I am. I'm Jason Karn. I'm the Chief Compliance Officer. I've been here since 2012 now. It's been a long time. And here is David Smith. We're so glad to have David here. David is one of our favorite presenters, or favorite guests here to have on the webinar here. So David, thank you again, as always, for joining us.
Thank you, Jason.
And let's go ahead and kick this off. I think we got a lot to cover. So I think the first place we should start, since this is still in our, fresh in our minds, and especially right now, is COVID, RSV, and flu, the three-headed hydra that we have going on. So can you talk a little bit about what we can and can't talk about when it comes to employers and insurance agents and everybody who's coming in contact with this?
I didn't realize the RSV looked so much like that asteroid that went by Earth a few years ago.
Yeah, what is it?
I mean, ultimately, the point about all three of these, the same rule it's always been, which is talk about just about as enough as you need to. Never say more than you have to. I've always said to people, and I've kind of continued to say it in the myriad of little COVID issues that have popped up lately, is if someone says they have COVID, someone says they have RSV or flu, I'd encourage them to stay home, not share more information than you have to, and to remember that ultimately oversharing as an employer can create some liabilities. Obviously, there's workplace safety concerns that always pop up, particularly around COVID, and there's a handful of rules out of the CDC and out of OSHA on that front. But again, the message is we're currently keep people aware of the fact that someone had something come up. Be mindful of workplace safety, but the specifics of who it is aren't relevant to making people aware of the importance of these kinds of transmittable diseases. The fact that someone is sick versus telling everybody that Jason's carrying all three and stay away from him like he's got the plague is the specificity that it has to with Jason isn't relevant to the bigger conversation.
Yeah. Okay. Yeah, I was going to have us drill down a little bit more on that. So, one of the things that we talk about a lot is, if I'm walking around telling people I have COVID, it's one thing, but once it becomes the possession of the organization, then that becomes PHI, and that's something that we really want to think about, that minimum necessary. What is the minimum amount? So and let's say David and I were working closely together, and Jillian may have to inform David that I had the plague or COVID, and so in that situation, David, how would you notify a party that, hey, they may have had close contact?
Hey, David, we've become aware of the fact that we've had an employee who's who's contracted COVID, RSV, flu, and we know that you've been in close proximity with a handful of people. Please be aware of that. Please get tested. Please go see your doctor to make sure that you're okay. Again, it's you've been in contact with someone, and they may turn around and say, was it Jason? It's like, I don't know that level of detail is necessary. I think it's more important that you look out for your own well-being. We're communicating with other employees who are in a similar situation.
Cool. Awesome. Thank you for that. I think that's helpful just to sort of have that script ready, because a lot of
Yeah,
times people do get caught flat-footed and they say, "Hey, it must have been Jason because I know he's homesick today or whatever." So,
yeah.
yeah. Uh,
Just always
and
assume
also
it's
with
safe.
that,
That's also safety.
yeah, yeah. And with that, it's probably not a bad idea to go ahead and say if somebody's had close contact, maybe they should work from home for a couple days just to sort
Yeah.
of stem that tide, as we all
Yeah,
know
and
that
we're in a totally different
is
place
real.
today than we were in 2020. I think people are a
Mhm.
lot more capable of working from home. And obviously there's the yin and the yang of working from home versus the advantages of people being together. But I think the temporary safety's better mentality is really one of those things that just seems very clear in the COVID, RSV, and flu spirit, or range of issues.
Right, right, for sure. All right. So jumping into HIPAA here, and this was kind of an eye-opening thing for me, was how many breaches are currently under investigation. So we have in the if you guys don't know about this, you can just Google the HIPAA Wall of Shame, and everybody who has been had a breach in the last God, since the beginning of HIPAA, you can pretty much see who's what company, how many people were affected, what kind of incident it was, and then the types of data that were breached, and if there was a business associate involved or not. And I put these in order of
The
the
count.
highest reported, which would be the hacking IT incident, down to improper disposal being, I think there's like 3 or 4 of those at this point. I think we've gotten a little bit better with that, and also because we have more centralized record storage. I guess my question for you here, David, is as we look at this and we're coming up close to the 60 days of reporting at the end of by the end of the calendar year of any breaches that are under your 500, is how many of these do you think are underreported? You
Oh,
know,
I think
like,
we probably underreport by probably at least a 50% amount. I mean, I think there's probably at least it's one of those things where, um, what's the old term from math, the difference between an average and a mean? I mean, if we look
mhm,
at the average is going to be a much higher count per person, because a hacking incident that involves millions of records is going to be a much higher value per se on an average. Whereas I would say the vast majority of things that are happening below 500 are usually in the unauthorized access disclosure range, or in
mhm.
the loss, improper disposal kinds of events. I do think it's also important for people to understand what each one of these things mean. Hacking IT incidents means someone's made an overt effort to access, usually successfully, and gotten access to information within the system. I always go back to the Anthem one from a few years ago, Jason, where they repeatedly said that we were the victims of a sophisticated hacking attack that caused us to lose access to these records, versus what I believe was announced earlier today about Humana having an unauthorized disclosure of information, which means they put that information out in a way that could be easily accessed by others. So hacking is
Mhm.
where you have someone literally attacking you. Disclosure is where you have information available in electronic formats, and someone has, and you've put it out in a place that it could be accessed without any firewalls or protections around it. So they
Okay.
put it on a website. Someone could literally find the website and then do something with it. Um,
Okay.
Theft is where usually there's been a physical effort for
Mhm.
someone to go into a database or into a computer and take the information out. So, comparing 1 and 3 is the difference between me sitting at my desk, hacking into your computer and getting the information, versus number 3, the theft is me getting in front of your computer on your desk and accessing that information.
Okay.
And so, you know, literally 1 and 3 are the same thing. It's just the means by which it's accomplished. And then
Right.
loss is where typically lost data is going to be in one of three forms. That's where you've got somebody who, there's information on a thumb drive and they've lost a thumb drive and it's unencrypted. They've lost a device, typically a computer. Since most phones and tablets are all encrypted, it's usually a laptop. Or loss could also include paper, where someone has had paper that they've misplaced, they've left in a gas station, in a restaurant, on top of their car, etc. And then improper disposal are almost always situations where, and I actually was on a call yesterday internally about this, where the question was, what do you do with old laptops? And the answer from our IT guy was, well, we typically will clean off the computer and then sell it back to the employee if they want to keep it. And the question was, well, what do you do with the hard drives? It's like, oh, we physically take the hard drive out of the computer and we destroy the hard drive, and then we buy a replacement hard drive and put in the computer, and that's what we give back to them. And so those are the situations that really kind of pop up in this process relative to the different kinds of incidents. But at the end of the day, hacking is an ongoing active business, because the valuable part of a hacking incident is coming in two forms. One of those is where someone has, done the getting that age, Jason, where little things like words escape me in the moment, but where they literally encrypt everything on your hard drive, put an entirely different password on it, and then want to sell you the password for X number of Bitcoins. Ransomware, that's the word. I couldn't think of it. See, you'll find, Jason, when you get to my age, give it 45 seconds, you'll remember the word. The other place that hacking and IT is valuable is the selling of the data. And if you don't think the data has value, how many times have you had a credit card taken out in your name in the last 12 months? And I can tell you personally, I've had 7 credit cards created in my name with my social security number, with my phone number, with my mailing address in the last 12 months. And all of that's because somebody has purchased all of that data out of someone else having hacked a database. And so they have all of that information, and they have enough to set up an account and to do it. And so each of these are very important, very real to people. That's how it happens.
Yeah. Well, and a couple little things that are questions I have around this actually is, where would you put social engineering in this? Is that really more of a hacking or an unauthorized disclosure use?
I would probably put social engineering in probably more of an unauthorized access issue.
Okay. Yeah. So just FYI, break that down for people that may not be familiar. Social engineering would be impersonating or trying to then exfiltrate or get information from somebody by pretending to be somebody else.
Right. It's Jason getting an email from me saying, "Hey, Jason, I need your ID and password because I'm trying to go in here and fix this thing on your computer," and go from there. Now, some would call that an IT incident, but it's really an unauthorized access question.
Yeah.
So,
okay, cool. Yeah. Be really careful around that. And then one other thing you said about the phones being encrypted. Yes. Android and iPhones are encrypted natively. Just make sure you haven't turned those passwords off, folks. Because if it's not password protected, you've lost all that protection. So I tell everybody all the time, I wish I could say I've never lost an iPhone. I've unfortunately lost 2 of them, which have slipped out of my pocket. And luckily, I make it so that you have to log on every time with Face ID, fingerprint ID, any biometrics. That is not that big of a lift, even to put in a passcode, and make sure your passcodes are 6 characters when you do those.
Yeah.
Just a little bit.
In fact, I would say something that's just happened. Apple has just turned on a feature on their operating system that will let you do protection of lost devices in a way that's totally different than what it's been done before. So it may actually reduce the number of stolen phones as a result of that.
Yeah, I saw an article on that saying that the stealing of iPhones, especially in Europe, is big business,
Yeah.
and that they are constantly, like, people are shoulder surfing, trying to steal your passcodes, and looking for ways in. So yeah, make sure that you have every time you log on to the phone that you have that, and any
Yeah.
data that you have access to within your phone that you have to then log in again. So it should be face IDs to get into bank accounts, into email, like any of those places where sensitive data is. The more difficult you make it, the better your life is going to be if you
I,
accidentally lose that
I'll tell
device.
you. I'll tell you a funny story I heard when I was in London over the holidays and was with a friend, and he was telling the story about having had his phone stolen, but that it was a two-man team, and apparently the other one had walked around him with the phone and was
Mhm.
able to generate enough of a face ID to bypass his face ID protections.
Wow, that's
So
crazy.
yeah, it's crazy.
Yeah. So, yeah, make sure you're keeping those devices safe. As I like to say, there's more computing power in your pocket than took us to the moon back in the '60s. So be careful with what you have on there and how you protect that data.
Yeah.
All right, now that we scared the crap out of everybody, let's talk about something that's and the reason I brought this up is I think this sort of feeds into everything going forward here in the rest of this deck as we move forward is what this HR 7898, so this is the HIPAA safe harbor, what this means for covered entities and business associates and what they have to do to be able to qualify for this exception. And if you could talk a little bit about this, David.
Well, I mean, so this was really it was trying to protect employers who were at least acting in good faith toward what they needed to do and still found themselves getting kind of hit for penalties. And so it was ultimately trying to make sure that there were recognized security practices adopted and put into place by the employer. And then if there was some kind of penalty, it was trying to reduce what the penalty would have been based on the fact that they were able to demonstrate that they had acted in good faith to comply. They'd adopted the security practices, and despite the fact that they'd put those things in place, they were still hacked. They had some kind of loss, and as a result, they faced a penalty. So the primary point was, if you do your piece, if you actually go out and take the steps that you need to implement the basically required that they couldn't increase the fine on you for having done that. That your compliance is going to be measured based on how consistently you had practiced or implemented those policies. They have to look at the fact that you had those in effect for at least 12 months prior to an attack before implementing any kind of fines, and that you've met the industry standard best practices in terms of trying to show that you did what you were going to do. It was, and I think you look at the example I gave you with Anthem, where Anthem got hit with a relatively large penalty, but their point was, hey, we did everything we were supposed to. We had good
Mhm.
policies, we had good practices, we were training everybody, but yet, yeah, we had a flaw in our system. That's what caused the hack to happen, but we didn't do it in a malicious way. So we shouldn't be hit with as high a penalties because of the fact that we were acting in good faith. And so really
Right.
ultimately this law was adopted to try and encourage people to do the right thing as much as possible.
Yeah. Well, and I guess that brings up, and you touched on this, but sort of to feed on this a little bit more is what is doing the right thing, and that the like best business practices include like showing training records. I mean, we've done our OCR audits and we've been through a few with clients. Is the first thing they ask is we want to see the last 2 to 3 years of training records. We want to see a thorough risk assessment, and we want to see policies and procedures and see that they've been enacted. And those are, it's high level of what they're looking for, but they're also are going to look for, did you do a risk assessment after the fact of your breach? how is this mitigated? Like, what steps have you taken, and the notifications that you've made towards individuals potentially, and to if it's and other entities along the way. So I don't know if you want to
Yeah,
talk on that.
I think really what this law came down to, and it goes back to one of those things, Jason, I know you and I have talked about for years, which is what HHS really wants to see people doing is that they've done something. And
Yeah.
the reason why this law was adopted was, all right, well, what does doing something mean? And now what they've done is they've actually defined what that means. That means ultimately, hey, we want you to have put in place security practices, that you've done the training, that you've done all the pieces that you need to, and you can demonstrate the fact that you did that. And so it's not like, well, I did something. I mean, I read the regulations and I told everybody what we needed to do. Well, that's not really enough. And so what they were trying to define is what's enough? What's enough to show that you've done something? And that's really where we are today is that it is, we need to have policies and procedures in place. We need to have training. We need to show that you have ongoing efforts to make sure that you're being serious about it. But we're not saying that you've got to demonstrate that you've got paid security guards outside the physical place where you're, how much is enough. And so that's really what they're saying. This is the threshold. Have done the training, the policies and procedures, the assessments, that you've done all the things that they expect you to do, because if you've done those things, then that should give you some cover for well, you weren't really doing enough. So it was effort from both the people being accused of doing something, but also from the perspective of the regulators. All right, well, where's that line? Where do we draw it? And in my experience, we're a lot better off with Congress saying this is what the standard is, rather than leaving it up to regulators to say, oh, well, we like Jason. We didn't expect as much out of Jason. But we don't like David, and David should have done a lot more. And we're gonna penalize David more just simply because we don't like David. And Jason did the exact same thing, but he doesn't have to pay as big a penalty.
Right. Yeah.
Because
so folks, make sure you're doing your annual training, and make sure you have real policies and procedures. Templates are not enough. We've seen that far too often when people print off templates and have them on a binder on a shelf, and that doesn't count. So make sure that you're really assessing what you have and making good faith efforts towards compliance.
Yeah.
All right. So this leads into, this is one of the big enforcement actions we've seen over the last couple of years. And we were just talking before this, as of December 15th last year, there have been 46 settlements around this. The last one was a $130,000 settlement that came out of this. So if you talk a little bit about what the OCR's right of access initiative is and how that applies to the groups that we're talking to today.
So, Jason talked about doing this since 2012. I've been talking about HIPAA since 2001, going back to working with your dad on what is now Total HIPAA today, your dad and your mom. And, for me, it's one of those things, people forget what the point of HIPAA was. HIPAA, when it was passed, was getting at the idea, HIPAA stands for the Health Insurance Portability and Accountability Act. And the portability was about saying, all right, we change coverage, then you're going to get credit for that prior coverage. But the accountability piece was all about trying to create administrative simplification. And administrative simplification means, how do we make it easier for there to be electronic payment of claims, electronic exchange of information between a carrier and a provider, or a health plan / employer and a TPA. So creating standards for how that data is going to be done. The HIPAA privacy and security regulations came out from that effort to try and create administrative simplification of healthcare data, and to try and create some efficiencies within how that data goes from point to point. So the HIPAA privacy rule and the HIPAA security rules both envision requirements where people whose data someone may have, a provider, a health plan, a business associate, that data still technically belongs to the person about whom that data is, gathered.
Yeah.
And so this right of access initiative is going at one of the core elements of the privacy rule, which says that data needs to be, accessible, and that it needs to be kind of protected in that process. And that means accessible. Sorry, excuse me. Accessible in the sense that if I call Jason up and he's my doctor, that they can pull up my records from 3 years ago, and they don't have to go pull it from it, or they can have to go pull it from a tape backup, but they have access to it. He can't call me up and say, "Hey, David, we purged those records. They're gone." So that is one of them. The second is that they can't restrict my access to it. And that's been really the biggest push on a lot of these. And a lot of this has been around medical practices not wanting to share full medical records with patients, usually around either a course of treatment or a malpractice issue. But they've also been relatively successful in going after some of the health insurers because of how they've made prior authorization or claim determinations and how much information they're sharing back with the patient or the patient's representative in that situation. And so ultimately what OCR, which is the Office of Civil Rights, which is the part under the United States Department of Health and Human Services that enforces all the HIPAA rules, what OCR is ultimately saying is the patient's data still belongs to the patient. And your ability as a provider, your ability as a health plan to deny access to the patient of their own information is very, very restricted. And they really can't do that. They have to give them their information. And so that's really been a big effort on their part to say, make sure you're not restricting access to their own information.
Right. Yeah, I think that's really important. Is folks, if anybody, any of your clients, any of your patients ask for information, access to that information, even if they owe you money, even if there's some some issues, you do need to give access to that. The only exception that I know of, David, maybe you can comment a little bit more on this, is the for those who are in mental health, is if you have personal notes within a mental health record, though those have to be protected like PHI, they are considered personal notes of the psychiatrist or psychologist.
Right.
And
And there are different levels of rules related to uh, medical records for mental health. So, for example, there's great restrictions on whether or not a therapist will be required to disclose all of their personal notes, because those personal notes will say, well, I was meeting with David last night and I'm pretty sure David is completely crazy and I don't know exactly what to do with him. So if he gave those records to me personally as his patient, then that would undermine the course of treatment and everything else. But the doctor's also required to maintain those records, or the therapist is required to maintain those records so that they can prove down the road if something happened that they did do a proper assessment and they did their best to try and treat that person in the best way possible. That's a really good point.
Yeah. And one other one might be, I think this was with the omnibus ruling, just to throw this one out there, is let's say I get lab work done and I go directly to like a lab core or whatever and try to get my records. They can deny access to those records if they believe that it would be dangerous for me to have that information directly without necessarily going through my physician. So like maybe like an HIV diagnosis or something along the way that might create some issue in between. There's something along that line, isn't there? Not, or
yeah, I think when you have somebody providing services through another provider, that they can restrict access to the means by which it's being paid for and accessed. But again, in those situations, there's probably a little more of a broad gray area than I would say that there are in the mental health records, because again, they'd have to prove that giving me my A1Cs directly from LabCorp as opposed to from my Duke provider isn't dangerous, right? So you've got to really kind of make sure you're being very specific about it.
Okay, great.
And I keep muting because I'm coughing, so I apologize.
No worries, no worries. So,
I don't have
I thought
RSV,
was
and I don't think you can transmit it over the internet.
I don't think you can. I don't think. Luckily, the only viruses we can get over the internet are not physical ones. I guess we get them on
Yeah.
our computers. But here's a fun question for us here. So, you wake up tomorrow to a headline: "There's been a major healthcare data breach, which exposes millions." What are 3 to 5 things that you do in the next 24 hours to avoid a PR and legal meltdown?
The very first thing is I start to figure out what's going on. What do you mean we had a breach? And let's figure out exactly what the cause of it was. I would say that the biggest mistake that people make is asking the "what just happened" question. What I've discovered through looking at and experiencing a handful of these situations is any belief that you have that this can be swept under the rug is ignoring the value and the strength of citizen journalism in the 21st century. And so there's no secret, no matter how much you believe your employees love you and trust you, that there isn't someone who's not going to reveal this if something like that's happened. And so rather than saying the first question isn't how can we cover this up? The first question isn't how do we minimize this? The first question has to be what happened? And then the second question is how do we keep this from happening again? You can have concurrent efforts going out to say, what are we going to say about this? But in my experience, this is a good example of something that in this day and age, any effort to minimize what happened is almost always going to blow up in your face. So if you don't know the answer to those first two questions, what happened and how can we keep it from happening again, then you are more than likely creating a very dire public relations problem for yourself. And by extension, a regulatory fine situation that could be even more dangerous.
We have raised
But that was
hands
only
here.
3, wasn't it? Did you
That
let me
was
get
that
all
was
5?
that was 2. You don't have to give all 5. I mean, I think that's a great place to start. I mean,
I do
I've
think you
seen.
need to have an idea about what you're going to say. And then I would say that what you're going to say is important. And then what are you going to do in terms of, and that question, that's probably actually the wrong question. The fourth question is, what do we have to do? Do we have to notify the feds? Do we have to notify the state attorney general's office? Do we have to notify the media? All of those are, what's our breach obligations in that situation? And then I think the fifth question is, what do we need to do for the people impacted by the breach? And I think, we've been working on something recently for someone, and the response from the subcontractor was like, well, we'll do this if we have to. And I think we were all struck by that language of like, what do you mean if we have to? I mean, are you really, you're not going to do anything unless someone complains? Is that really the approach you're going to take? But I think it really highlights a lot of this. And again, if I'm going to keep adding things to my list, in the midst of the first and second questions, a lot of times what we're finding is first party information holders are very rarely nowadays the people who caused a breach. I mean, it's happening, but I think from the glance of the Humana article that I read earlier today, that was again not something that someone within Humana had done. That was something where one of their subcontractors had been the cause of the breach, but ultimately it was Humana's responsibility. And so in the course of 1 and 2 is also, how do we make sure when this doesn't happen again, that we've got all of the other parties who hold any PHI for us aware of what they need to do and how to protect us?
Yeah. And I think this brings up some really good points about making sure what we have that you have things in place beforehand,
Yeah.
because it's really hard, especially under the pressure of figuring out what happened, how do we not have this happen again, and all these things. It makes your life a lot easier if in you prior to this you have a breach plan. You know how you're going to notify people. You know how you're, what the notification process is going to be, and have a plan prior, which is part of HIPAA compliance. And it really makes that streamlines that process a lot more. A little bit of pain today makes tomorrow easier, kind of thought along the way. But the thing I think it brings up, and we've talked a lot about this recently, is that what kind of indemnification do you have in those business associate agreements? Do you have indemnification clauses in there that that they're going to pick up the tab if they have a mistake, if they make a mistake? Are they going to make sure that they have credit monitoring in place for your
Right.
clients, for your patients, to make sure that you're protected? Or are you going to have to go to court to then become whole again, which puts you in a difficult position also?
Yeah, absolutely. And I think in the indemnification, um, issue is going to be a bigger and bigger concern, I think, over the next 2 to 3 years, because it is a lot of these breaches are happening by third parties. And I know,
Hmm.
we've written a couple things, and I think this is really a great concern that I have about how these third parties who are willing to provide you these services but aren't willing to take responsibility for when they have a breach that impacts you as a first line, covered
Right.
entity.
Yeah, it makes you wonder, these business associate agreements sometimes aren't worth the paper they're printed on when it comes down to it, that they're
No,
just, we did it because the feds made us do it, but otherwise we're not really going to back up what we signed
that's
up
right.
for here.
That's right.
Right. Um, so here's some fun stuff here. What's the most mind-boggling HIPAA misconception you've encountered?
Um, I mean, I think I've seen both ends of it. The first of which is people wanting things to be part of HIPAA that aren't.
Mhm.
And so I think we run into, now I would say the scope of what is included within HIPAA, meaning PHI, is a lot broader than it once was. But I
Mhm.
mean, I've seen situations where people have said, "Hey, I, they've got my name on a check-in sheet at the doctor's office. Is that a HIPAA violation?" It's like,
Mhm.
no, because I mean, again, I think that's where you start to. I see more and more of these questions um, about whether or not there is a something is HIPAA applied, and then I think on the
Mhm.
other side has probably been, I think probably around indemnifications for me. It's like, well, what do you mean we should take responsibility? I'm like, all right, I give you data. I think we talked to an insurance, somebody who does a lot of work for insurance agencies last year, and their business is providing back office systems for insurance agencies. So they
Mhm.
literally, their business is, I'm an agent and I'm putting stuff in a filing system that's electronic. That way my employees can all access it. They're providing the back office. So they're
Mhm.
holding all of this data for the agency. It's like, well,
Right.
why would we be responsible if there was a breach? It's like, I'm sorry,
Yeah.
what? It's like, we just don't understand. It's like, all right, you as a vendor have your systems accessed improperly, either by one of your
Mhm.
employees or by hacking. And as a result,
Mhm.
I'm an insurance agent and I've chosen to hire you as a company to hold on to all this information. Now you've had a breach, and I've got to go out and tell all of my customers and all of my
Mhm.
carriers that I do business with that I didn't have a mistake, but that you as my vendor had a mistake, and my business gets decimated by your mistake and you're not going to protect me. That has probably been the most mind-boggling
Mhm.
conversation I've had, because it's
Yeah.
almost like, I mean, it's the mindset of automakers, in the 60s of, well, just because we created a defective product and you chose to buy it doesn't mean that we're still liable. You bought it. You
Right.
signed this paperwork saying you're assuming all liability for the product after you bought it. You're like, yeah, but you sold us a bad product. That's the mentality. Like, we have no liability for what that means. So
yeah. No, that is mind-boggling. I mean, especially because I remember when I got my first car, it was a 1970 Dodge Polara, and the dashboard was so hard on that thing, I thought I'd lose my teeth just from bending over to pull the lights out. So, but yeah, that's a great analogy because we have this situation where it is mind-boggling. I mean, the fact that we have these multi-million-dollar companies who are saying they're going to be custodians of our information, they've signed the business associate agreement, but yet they refuse to sign an agreement that will make you whole if they have an issue. And let's be honest, just because they're a big provider, they're a Google, they're a Microsoft, they're whatever, it doesn't make them immune. Now, chances are they've got great security on things, but we've seen some really large hacks that happen, and some really large issues that come from some of these providers. And there needs to be some way for you to make sure you're made whole. I always bring up with the Poneman Institute that they do the annual survey with IBM, which, by the way, healthcare costs or healthcare records are the get the most money in the dark web. I think it's like $5 or $10 per record in the surveys. But the interesting thing in there is they say you can expect to lose somewhere between 40 to 60% of your business by having a breach. So, you got to be really careful. You got to look on your face like you don't.
No, I believe it. I have seen. I mean, it's like you. We've seen crazy crap. And I would say that for a long time, I mean, I think, we talk about the cycles of Earth and, what era we're in. I think the HIPAA thing has been a great example of the same kind of era mentality where for a long time we lived in the era of like, well, nothing's ever going to happen. And there's never going to enforce this. And then when they started enforcing it, it was at one level, kind of the bad actors, the worst actors kind of enforcement. And now what's happened is all of a sudden the vendors who have been in whatever space they're in have suddenly realized that, oh, wait, we're doing things that could actually create liability for us. And our first reaction is to say, hey, we've got no liability. And then the question is going to be now, how much do market forces change their mentality, or how much does regulation force a change in mentality?
Right.
And it's truly the intersection between the regulators, public relations, and frankly, their insurers, who are all going to create whatever middle ground exists there. Because the regulator is going to say, hey, if you made the mistake, you should be liable. The party who's actually made the mistake, their cyber insurance liability carriers are all saying, oh, no, we don't want that liability. Or if you're going to assume that liability, you're going to have to pay a lot more in insurance policies to cover that liability. But but ultimately, market force is, hey, I'm not going to do business with you if you're not willing to protect me. And that's going to come down to how much market power does the buyer and the seller have in those environments.
Yeah.
What we've seen, and, you and I have both seen these, but you and I have seen people really embrace their HIPAA responsibilities. I know Microsoft has been very diligent about it. Google's been diligent about it. Dropbox has been diligent about making sure that they've got HIPAA compliant products available. And so you see these huge companies doing something. So it's kind of like what we're finding is this medium level company that have good, strong businesses, but they don't want to take the liability because frankly, they don't want to pay the insurance premiums to assume that liability.
Yeah, for sure. I'm going to skip ahead here a little bit because we're getting a little short on time. We got a lot of questions that came in. So I want to make.
Sorry.
Nah, it's good. This is great. Never would I love, and I think it's been a fantastic conversation, and I hope everybody's been enjoying this. I just want to make sure we have enough time to get to the questions. But What updates do you expect in 2024? I know we're in a legislative deadlock, and I don't want to get too far down the political rabbit hole, but what updates are you expecting from, I guess, from industry forces, maybe more so than regulatory forces?
Yeah, I don't know that I see a lot happening in Congress or regulatorily. I mean, I think right now, I still feel like a lot of the Biden administration's mentality has been to enforce the regulations that are there and to start challenging where there needs to be new regulations. We've seen that happen on a handful of fronts, particularly in the employee benefit space. I think with HIPAA, what they're doing is they're looking at more and more examples of people doing bad things and stupid things. And so what I see more happening out of the regulatory enforcement side is more directives at bad acts and more advice about how to avoid stupid acts. And so it's a reason why that indemnification question I think is so fresh, is because the indemnification issue is becoming a bad act in the eyes of some in Washington. And so ultimately, as we look at where this is going, I think you'll see more and more of that. What are the things that people are doing that are just overtly bad? And how do we make it clear to everybody you can't do it? And then how do we help give people good advice about avoiding doing things that are, inherently stupid or accidental? But like, I don't see, I think between high tech and a lot of the things that Congress has passed over the last 10 or 15 years, I think they feel like they've got a good regulatory environment. I don't, if anything, you see the biggest push around how do we make it easier for data to be exchanged in research environments? How do we make it clear that information can be exchanged between providers? And I think a lot of people are trying to find that balancing act between how do I do this and not create a problem for myself versus how do I do this, or how do I choose to not do this and make it as difficult as possible, which may undermine someone's either health or the payment for those treatments that they may need.
Okay, great. All right. Well, we're on to the audience questions portion here. We got some great questions. I'm going to start in reverse order here because I think this is something that comes up a lot. This is a question from Dean. Thank you, Dean. If there's a breach between a business associate and a primary company or covered entity, what should be the interaction between the two internally and publicly to address the issue?
Well, I would say that the times that I've seen this happen, keep in mind, prior to high tech, it was ultimately only the covered entity's responsibility. Now, because of high tech, the covered entity can be the one actually blamed and assume blame for that. I think it all depends on how big the covered entity is. And so a lot of times the covered entity is saying, hey, this happened. It happened with the vendor of ours. But then the smaller that the covered entity is, the more likely they are to let the business associate take liability. I think then we dealt with the TPA issue recently with something related to a flexible spending account invoice. Maybe that's not been recently, been like the last couple of years. And in that situation, it wasn't that the employer was out saying to their employees, hey, we had a breach, this happened. It was, you're the business associate. It is your job to tell our employees who were impacted by this what happened. And I think that communication is really a lot of times about the PR side of it. And so I think that as an employer or as a covered entity in those situations, you may want to make sure that you're clear about how the communication is going, or even to do some, hey, we've been aware of the fact that ABC vendor had a breach and they made a mistake, and we had information about 5 of our employees who was disclosed improperly. We're going to do this for the 5 employees, but be aware of the fact that we take this seriously. We're reevaluating our relationship with ABC vendor, but ultimately it's ABC vendor's job to say to those 5 employees, hey, we screwed up. This is what happened. This is what we've done to fix it. We're giving you identity theft protection over the next 3 years, and here's how you take advantage of that. And so I do think it's very much about how you want to control the message.
So in that situation, building off that, is that the responsibility of the covered entity or is it that the responsibility of the business associate, or does it depend on the size, I guess, of each company as to who
It depends on the
notifies
business associate agreement.
HHS? Okay.
Because again,
Business.
if you read the regulations that say when the business associate is the one that created the breach, they're the ones that have the breach notification obligations. But if you as a covered entity, or even what we've now seen, the kind of third line breach where you got the client and now you're the business associate and one of your business associate, a business associate subcontractor created the mistake, then what's my client expecting? What am I supposed to be doing? The regulations would say ultimately the breaching party is the one who has the breach notification obligations. But again, sometimes you want to control that. But man, you and I have seen business associate agreements over the last, couple, 3 years where it's like, yeah, if there's a breach, we'll share the information with you, but we're not doing breach notifications. And we're like, what are you talking about?
Yeah. And that puts you in a really sticky spot there. One, and two, also it could be there's some real issues with different states, because we now need to take into account the state notification, what their guidelines are and what their thresholds are, which can get really sticky really quickly. So
yes.
All right. This goes, I think we sort of answered this, but I think it's not a bad one to go back with. Tommy, thank you for sending this in. Are there specific BAAs or business associate agreements that we can require that hold particular language with them, assuming responsibility for a breach?
I think our standard BAA and BAS all do have very specific kind of language that says, hey, you're going to take on the responsibility of providing the breach notification, and includes indemnification language. So I think, my advice would be to use what's in the packet of stuff that Total HIPAA has, because it's the one that's going to protect you the most. We want to make sure that ultimately the breaching party is who ought to provide the breach notification. The breaching party is the one who ought to be protecting and indemnifying the person for whom they've been entrusted data. And so I think all of those are the best way to do it. I know that for us in our business associate agreements say that we, as a business associate, will provide breach notification for our clients, that will indemnify them in those situations. That's just a responsible business position to take.
Right. Yeah. So if you have specific questions around that, feel free to reach out and we can talk to you about that. Okay. Let's see. The next one is, okay, let's see. I represent an employer, have found HIPAA compliance issues. What would be the first steps to becoming HIPAA compliant for employers? That's
obviously the first thing you do is a risk assessment. I think you've got to start with the risk assessment to really know what you're dealing with. Second is always training. You got to make sure that people are aware of what their responsibilities are. And that means dividing out that responsibility. I've got clients who have thousands of employees. You're not doing HIPAA training in most employer situations for 1,000 employees. You're doing it for the handful who get access to the PHI. And so particularly if you're an employer who has a self-funded health plan, we're talking about the people in finance who may see detailed claims data. The same thing with people within HR who will have access to the same. But other than that, it's a matter of then doing training that's kind of HIPAA light for supervisors and managers to understand what they can and can't talk about as it relates to HIPAA and health data inside of the workplace. But ultimately, I think that the risk assessment is going to identify where your problems are, whether that's access, whether that's emails and encryption, whether that's simply making sure you got proper training. The whole purpose of risk assessment is to tell you where your problems are.
Yeah. We see some interesting things we go down when we do those risk assessments. It's quite It's like seeing behind the curtain in the Wizard of Oz. You get to see the guy pulling all with all the things are being pulled and whatnot. So,
like, your file cabinets are where?
yeah, yeah. I've seen. I've seen some that are like, what is it? They say they encrypt everything in transit and storage and are at rest, transit, and storage, and then they turn around and they're like, yeah, we don't encrypt our NAS, we don't encrypt our server, and you're like, what are we talking about here?
I mean, I had a conversation, and it's been 3 or 4 years. I feel like I always tell the story. But it's like, within my company, it's like every time we get a new laptop, I told my IT guys, like, called him one day. It's like, are we encrypting every laptop that we buy and we give to our employees? He's like, no, because honestly, it slows down the computers just a little bit. And like some people complained about it. It's like, all right, dude, I'm hanging up the phone now. And I'm going to call you back in 5 minutes, and you're going to have a different answer to this question. And then you're going to start actually encrypting all the hard drives. Because it's just like, how do you get there? How do you not automatically encrypt a hard drive?
It is a no-brainer, and especially because if you lose a device, which we've had clients who've had devices stolen, and it's not that far of a stretch, and you then have to report that as a breach. You have to assume that's a breach at that point. And and then you think about it's such a low bar. And processors these days are fast enough that you should, and if, let's be honest, if the thing's slowing down a little bit, then probably you need a newer computer, or maybe a little more RAM in that device. But it shouldn't really be, you shouldn't notice a difference. Here's an interesting sort of going back to the beginning here, but I think it's worth stating. This question is from Andrea. Do we have to notify employees if they've been in close contact with COVID, RSV, or other illnesses? And I think that's an interesting way of putting it.
Do you have to? So the real question is, what does the CDC and what does OSHA say about this? On the COVID side, that question has now has come down to whether or not the person who has contracted COVID has been vaccinated, and what the obligations are from there. So pardon me. And so I just lost my train of thought
about OSHA and
and so
CDC.
I mean, I guess the question is, and I hear the do we have to, which unfortunately in this environment feels kind of a political kind of question. I think ultimately the question is, do you want all your employees to be out of work for a week because there's been a rampant spread of COVID and therefore they can't come to work? And so for me, it's often about also protecting your workplace. Yeah.
I mean, I think I don't know that you have to, but it falls under that best business practice. Things that are just the right things to do. Just make sure, again, as we stated earlier, minimum necessary. Make sure you're just saying that you've been in close contact, no specifics. It's one thing if I walk around and tell everybody that I have COVID versus the organization saying Jason has COVID.
That's right.
So, all right. Well, we got one more, but we're right about at time, so I want to let everybody get back to things. What we'll do is we'll reach out with the additional questions that I have here, and let you guys know. If you have further questions, please reach out. We really appreciate everybody's attending. You can reach us at totalhipaa.com. And if you need any help with your policies and procedures and your HIPAA plans, please set up an appointment with us. We'd love to discuss more of what your needs are and get into that with you. But David, as always, thank you so much for your time today. We really appreciate it. And we will be in touch soon. So thank you, everybody. Be safe and take care.